I would ask you if you'd keep your questions to the end. You will have plenty of time for that, so we can move right along. I'd also like to, at this time, ask if we have any pastors with us or any elders from any of the churches locally. Any of those that would stand? No one? Okay, we've got one. Oh, okay. Any of our government people?
You said elder, didn't you?
Pastors and elders from the church.
Elder.
Okay, good. Thank you. And any of our government leaders at any particular level of government? Speakers. I believe it's very important for us to give honor where honor is due, and we'd also like to give some honor to all of you for coming. So we'll just quickly stand. I'd like you to introduce yourself and tell us where you're coming from. Briefly, just tell us, my name is Gary Gaham, and I come from
Merrimack.
Merrimack. Thank you. Okay, that's the example I picked on you. See, we believe in the volunteer system. You're the one. Okay.
I'm Twombly, Nashua, president of Nashua Public Warnings.
Yes.
Jamie Chris from Milton.
Okay.
Connie Phelps, Stratham,
Good. See Joseph.
advocate expert.
Wonderful. First of our capitals.
Yes, I'm an architect from California, just visiting.
No, he lives here, Exeter. I won't let him go back.
Good. He belongs here. It's better here. Start over here.
Joe Frazier from Canaan.
Okay. Ben Salville from Canaan.
Roy Schultz from Manchester.
Shout it out now, folks, because this is being recorded. Your names are being registered.
Ingbretson, Manchester.
Pam Ian Concord.
Good.
Bill McNally, Windham.
And Father Pratt, Bedford.
Don Colafrat, Bedford.
John Yescovich, escaped from the People's Republic of the South, granted asylum in where?
Paul Gagnon from Manchester.
I'll get it. You're a rerun. Gary Hand Merrimack.
Andy Bridge from Amherst.
Karen Holcomb, Bennington, and I want you to introduce yourself.
I'll get to that. I was hoping that you weren't going to introduce your nephew.
No, I want to know who you are. You didn't introduce yourself to us.
Sure I did. I told you when you came.
No, but I meant to the whole group.
Okay, I'll get to that.
Betsy Bridge, Amherst.
Joshua Holmes, Sunderwood, Manchester.
Don't be shy.
David Scott, Dover.
Rita Scott, Dover.
Right.
Bruce Allen, Concord. Will Domenico, Manchester. Skip Murphy, GrantCroc, Guildford.
Rob Yaakov, Manchester.
Norman Tregenza, Carroll County.
Morgan, Manchester.
And in the back, two students from this fine institution, John and Tara, who are helping us tonight. We also want to greet them. Give them a round of applause. And being that, Joan, you have asked me to do that, it is Joan, right?
Sharon.
Sharon, okay, sorry. My name is Garrett Lear, humble servant of the Lord, also known as the Patriot Pastor. Years ago, when I started, oh, we get some more? Of course, how can we forget that side over there? But you didn't jump in.
Harriet Paving, Deerfield.
Mel Winters, Fremont.
Pat Sutcliffe, Epping.
Diane Gilbert, Epping.
J. Claire National.
Is that Harry Caddy, the troubler of Deerfield? The one that walks around with a cast on her foot, looking for sympathy when she's sneaking up on you? Harriet is a former representative, still staying involved. Appreciate that so much. And I was touched by a number of things that the speakers have already said, including what Representative Mirski was talking about, reading the Constitution. Folks, this is absolutely abysmal to think that in Washington there are people who have never read it. There are people at our State House who are elected representatives, they've never read it. Now here's the sad thing about that. They've taken an oath to uphold something that they don't even know. And it's interesting, Noah Webster, and in his dictionary of the American language, 1828, said that a solemn affirmation or declaration made with an appeal to God for the truth of what is affirmed. The appeal to God in an oath implies that the person imprecates his vengeance and renounces his favor if the declaration is false. Or if the declaration is a promise, the person invokes the vengeance of God if he should fail to fulfill it. A false oath is called perjury. Thank you, Representative. Perjury. We had a Supreme Court justice go to a foreign country where we have much conflict and state that she did not like the American Constitution as well as the one in South Africa. I have the liberty to make a few ad-libs here. If I were President of the United States or anybody in an authority to do so, I would have revoked her passport. I would have said, stay there, in fact, go to South Africa. Or I would have said, if you'd like to come home, if you call this home, we'll be waiting for you at the airport where we will escort you to a jail cell. For the very reason that I just read to you from Noah Webster. This is not radical stuff, folks. What you're hearing from these representatives is so important. And by the way, who was the one that was accredited our New Hampshire model? He was the hero of Bunker Hill. General John Stark. And if you look above the Main Street entrance of our State House, and I hope you'll do that, what do you see there? You see the ancient seal, and it says the Republic of New Hampshire. Isn't that interesting? Then you see on the ancient seal, and I believe Representative Itse has one on him at the moment, it says, Vicinita Fortior, which means union makes strength stronger. They knew something about that then. We need to know something about that now. And you will see 3 pictures there. A codfish, we've got a lot of them here. 5 arrows tied together, the original 5 colonies, and a pine tree. We got a lot of those, don't we? Well, I'd like to introduce our next speaker as he makes his way here to the rostrum. He's got quite a curriculum vitae here. He's going to be speaking on instances of judicial overreach case history. Greg Sorg is an advocate of constitutional government, a practicing attorney with degrees in American history and a Juris Doctor from the Washington and Lee University School of Law. Attorney Sorg was admitted to the practice of law in the District of Columbia. Now that's pretty admirable, knowing what goes on there. In 1977, and then in New Hampshire in 1981. He's also a current member of the New Hampshire General Court, which is known as what? The House of Representatives, where he's vice chairman. He's not the chairman of vice, but he's the vice chairman of the House Committee on Constitutional Review and Statutory Recodification, a former vice chairman of the House Committee on Judiciary, and Attorney Sorg is also a co-sponsor, gladly I can say, of CACR 26. Representative Sorg.
Thank you very much. As Representative Mirski said a little while ago, it's very difficult to know where to start. There's so much to say, and I'll confess that I came here, I'm flying without a net because knowing I was going to follow Representative Mirski and Representative Itse, I figured they would cover the subjects I might have covered much better than I did, and they certainly did do that. I think what I would like to do, before I get into specific instances of court's violation of our rights, is to go back in time a little and to see what the source of the problem is. And as is so often the case when you're doing some constitutional archaeology, you really need to go across the water. I often tell people you can't have a real understanding of what our Constitution is all about, federal or state, without having at least a working understanding of what went on in 17th century England. I will tell people that our English forebears really did a lot of the heavy lifting for us. That was a very tumultuous century. As you probably know, when Queen Elizabeth I died in 1603, that brought an end to the Tudor dynasty, much to the relief of the people who had to bear much under the near absolutism of the Tudors. And it didn't help the cause of royalty that the successors, the House of Stuart from Scotland, were also very inept politically. 3 of the 4 of them were quite self-destructive. And so in the course of that century, there were battles between Parliament and the King over the right to tax and the control of the Judiciary, which is relevant to what we're going to get into. And they had a civil war in the 1640s. The king was beheaded. There was a commonwealth for a while in which they gave a good try at democracy and learned through trial and error what works and what doesn't. But ultimately, they restored the monarchy. Charles II was a much more adept monarch than his father and grandfather had been. But his brother, James II, who succeeded him in 1685, was definitely not. And as often happens when there are bad kings in England, the rights of the people advance. That's when we make the most progress. Think of John and Runnymede, the Magna Carta, and you think of Henry III and the model parliament. Well, this was James II, and what he brought about was the Bill of Rights. But he also brought about indirectly something else that's relevant to what we're dealing with here, and that is the creation of what's known as the independent judiciary, which was a great stride forward. In 1701, and it's fitting that it was right at the beginning of the 18th century this was done, Parliament found that it had a little unfinished business from the Glorious Revolution of 1688, by which James unceremoniously fled over to France to the protection of Louis XIV. They found they had another problem. When James left the throne vacant, Parliament provided for the succession of his daughter Mary and her husband William III, because they were safely Protestant. And after that, because they were childless, would come Mary's younger sister Anne, another daughter of James II, who was also safely Protestant. And then everything would be fine, because although Mary and William and Mary didn't have any children, Anne had, I think he had numerous children over the course of her life. But a funny thing happened. I think the heir to the throne died of tetanus in the late 1690s. And now there was a problem again, because Mary had no other children and there was going to have to be provision made. So Parliament met and enacted the Act of Settlement in 1701, which provided for the eventual transfer of authority of the monarchy to the House of Hanover, Empress Sophie and her heirs, and that led to the 4 Georges for the next 100 years. But as a small part of that, they also dealt with a matter that had been left over from the Glorious Revolution, and that was what to do with the judiciary, because one of the sore points between King and Parliament all through the century had been the fact that judges served at the pleasure of the king. And in the battles over who controlled the purse string, the king was always coming up with these ancient taxes that had been in disuse for many centuries in some cases, and the courts had always upheld his right to impose those taxes so that he could rule essentially without Parliament. There was also a very bad reaction to the bloody assizes in 1685 that followed the suppression of Monmouth's rebellion. You may remember that one. An illegitimate son of Charles II decided to assert a right to the throne. his followers were very quickly dealt with, and the matter could have been brushed aside as a minor skirmish, except that James, he was determined to make an example of everybody who had rebelled against him, and just held a session of courts in the West Country that was just appalling in its arbitrariness and brutality, and forever sullied the reputation of Lord George Jeffreys, who was the judge in charge of that. And I think it left to his own devices. Lord Jeffreys would very gladly not have done that, but he served at the pleasure of the king, and he had to act against his own conscience and preferences and understanding of what was just. So they wanted to do away with that control that the executive had over the judiciary. They briefly considered, but instantaneously rejected the idea that the judges should serve at the pleasure of Parliament, because one election and all the office holders could go. It would just be a bad situation perpetrated by Parliament that had been perpetrated by the king. So what they did was make the judiciary independent, and they did it through essentially two things. Number one, they would serve during good behavior. That was the term they used in the Act of Settlement, and that's carried right through to the federal Constitution and to our Constitution. And their decisions would be respected. Now, under the English system, watching the constitutional development of England is a wonderful thing to behold, because they never, unlike us, they never had a constitutional convention. They didn't go to some central place like Manchester in England and put all the eminent people together and come up with a form of government. It evolved over time, trial and error. And the Act of Settlement's determination of how the judiciary should be handled was one of those. It was a dangerous experiment, they felt, because you're putting people beyond control of the political process and what might happen. The idea, of course, was to keep the judiciary free of the contagion of politics emanating from Parliament. But the question was, what happens if the judiciary should itself act from political motivations? How do you protect Parliament from that? Well, the practical English solution was just written right into it. Number one, since the courts were the creation of Parliament, they could reconstitute the courts at will. They could use the power of impeachment, and they used it much more liberally than we do. One of our problems is that these powers of impeachment and address are just virtually dormant. They're hardly ever used. They're highly personal, and everybody shrinks away from them. But the English were more apt to use them. They were more effective than they've been here. But the big thing that acts as a check on the judiciary is they have to put their opinions in writing. You have to, in order to check that their decisions are not politically motivated, they give written opinions expressing their reasons, and you review them. And if Parliament didn't think the reasons amounted to enough, they could just by ordinary enactment of legislation change them. Not for that case, that the results of that case would be binding on the parties that had come before them, because that was part of the bargain. Their decisions would be respected, but they could change the law at will for future cases. So that's all well and good. Now now that's all carried over to our country too. And what has happened is that we have lost sight of this valuable tool that's available to us to examine the reasoning behind the court's decisions. And I would say that it is not only our right in the legislature to see, to put it colloquially, whether a decision of the judiciary passes the laugh test. It's our duty to do it. Otherwise, we're just subject to an arbitrary authority that can impose its will from political motivations without any check, which is what has happened. And that brings me to fast forward to modern times here and give several examples of how that's happened. The first, and one that's known to all of you, I'm sure, is Claremont versus Governor from 1993, and there have been, I think, 13 successor Claremont cases dealing with one aspect of it or another. But what happened in Claremont is that the Supreme Court decided that Article 83, which requires the legislators at all future times to cherish the interest of education among 16 other things that we should take an interest in. But they singled that out and said that that's a fundamental right, and that required the legislature to provide an adequate education with sufficient funding entirely from state resources. And they did that all based upon what Article 83 said. Now, how they determined what Article 83 meant, they chose quite properly to go back to what the words in the Constitution would have meant to the people at the time of its ratification. A perfectly reasonable standard. But what they did was falsify the history. They took a few snippets out of a speech here by one of the governors, Wentworth. Now, they're great authorities on the Constitution of New Hampshire. The last, I think this Representative Mirski could tell you that last time, was it John Wentworth, I think was the last royal governor. The last time he was seen, he was rowing furiously out to a British man of war to hightail it to Halifax because he wanted to avoid the proverbial tar and feathers. And yet he's one of the people quoted in the Claremont case as expressing a view that it was the intention of our founding fathers, both before and after the Constitution was created, to provide a state-funded education for everybody. They quoted a couple of out-of-context things from histories of New Hampshire. And what they didn't do glaringly was tell us what did the legislature, after the ratification of the Constitution, what did they actually do? And the reason they avoided that, because what would hit them right away was that the legislature in 1789 passed an Education Act, which completely revamped how education was handled in New Hampshire, obligated all the localities to provide education, but to pay for it locally. They didn't want that to get out. That would undermine the entire effort of the Claremont decisions. So they falsify history. And it's obvious that the history is falsified. I read that decision and I said, if they can get away with this, they can get away with anything. And that's when I first became interested in the state government, frankly. I'd been here 13 years and enjoying the liberty we have here without really taking much of an interest in its preservation. I was just a workaday lawyer until I read that decision. And that's when I became interested in state government, because I think if our republics, federal and state, don't survive, it's not going to be because of any foreign invaders that are going to do us in. It's going to be ourselves from our own civic laziness. A good part of which is acquiescence in the judicial tyranny that they have built up over time, and our own unwillingness to confront them about it. We just accept their decisions at face value, and we've been, in the case of Claremont, we've been struggling for what is it, 18 years now, trying to deal with it. And the education funding amendment that's before the legislature now, CACR 12, is, even though we might have to do something of that sort, it really irritates me, because what we're doing is covering for the court. They committed a constitutional crime, and we're going to cover it over by, in effect, saying it was legitimate because we feel we have to amend the Constitution to get rid of it, when what we should have been doing right from the start is just maybe taking a copy of it, ripping it up into shreds, putting it in an envelope, and sending it over to John Doe Drive to tell them just exactly what we thought of it. But we've been so conditioned over time to believe that anything the court says about the Constitution, no matter how ridiculous, is binding on us simply because the court has said it. It's kind of a secular version of the doctrine of papal infallibility in matters of faith. And that's fatal. It's going to be fatal to our Republican form of government if we do not recognize that and do something about it. A more recent instance of judicial overreach was in 2006, in which they ruled that the ballot arranged alphabetically by party with Republican, Democrat, Independent, however they arranged it, was unconstitutional. They based that on a provision of the Constitution, I think it was Article 11 in Part 1, that says that every person shall have the right to, maybe it's Part 2, Article 11, it's in Article 11. Everyone shall have an equal right to to be elected to office. Every voter has the right to be elected to office. And they decided that listing people alphabetically somehow offended the rights of people down there like myself, whose last names begin with S and letters below that, in these districts where there are many members for the House. Down here in the southern part of the state, some of these legislative districts have 10 to, I think, 14 representatives, and there had to be some way to organize them. And incidentally, those multi-member districts were created by the court when it took responsibility for reapportioning the state in 2002. So the problems are self-created. But the legislature passed a law providing that the ballot should be arranged alphabetically, which is a perfectly reasonable way to do it. And because the Republicans were in power, they set it up so, I think, so the Republican Party was listed first and the Democrat to the right of that. So you'd see the Republicans first and presumably would maybe give preference to Republicans, because if you don't know much about the candidates and you want to get out of the voting place first, then presumably you're just going to check off the first people you see. That's the respect that judges have for you folks. I think that's very, very typical and very telling. They didn't they didn't tell us what the Constitution required us to do. That we're supposed to guess that, and that's an amazing, because from the very earliest days of constitutional adjudication, the courts would say that if the Constitution requires something to be done, it's very clear, and they would tell us what the rules are. But they've taken it the other way now. If there's general language in the Constitution, they will say, well, what you did is not right, but we're not going to tell you what the right answer is. You're just going to have to keep trying again and come back, and we'll say, no, not yet. Come back again. That's why we've had so many Claremont decisions. And they did the same thing with the ballot case. That was Akins versus Secretary of State in 2006. So what do? If you can't use the alphabet as the way to organize, and you can't put the parties down in a certain order, what do? Well, you have to essentially put them into a hopper and come up with something different. My cousin in Exeter offered a very interesting solution to that. She said the ballot ought to be round. So you maybe put the Republicans around like spokes on a wheel in these multi-member districts. So nobody's first, nobody's last. And then you put the Democrats inside in an inner wheel and put a little pivot in the middle, so you can spin them around so there's no Democrat right next to the same Republican all the time. And that way no one's famous. Because what happened was, I participated in some recounts from those districts. How am I doing on time? See, it's amazing how fast it goes by when you're having such a great time. And I would find that you'd have a Republican list and a Democrat list, 13 candidates, and the way the voters voted, you could see that they thought, well, this Republican is next to this Democrat, so the contest is between this Democrat and this Republican, this Democrat and this Republican, so they would check this around there as if it was 13 different races, one against the other. That's what the Supreme Court gave us, because when people couldn't, if it had been arranged alphabetically, people would have caught on that that's what it is. It's just an alphabetical list. It's not anything to do with these people being against each other. That's what happens when you exercise arbitrary authority and solve a problem just to create another one that's far worse and real, because they never proved that the other one was actually a problem. I have one other I'll mention before my time is up, and that happened last summer. We had a bill, House Bill 89, which called upon the Attorney General to join the lawsuit against Obamacare. And it was a directive, and there were tons of precedent for that. Representative Itse could tell you. I don't know, anyone knows more about the Constitution and constitutional history of the state than Representative Itse. Many examples he cited which that had been done in the past. Well, the Supreme Court said no, because Article 41, having to do with the powers of the governor, was amended back in the 60s as one of those mischievous amendments that Representative Mirski was referring to. And that gave total authority over direction of the Attorney General to the governor. And when that decision was handed down, it was given some study in the legislature. We found the court was just wrong. It was just factually wrong, because the history of the amendment in the Constitutional Convention showed that the very delegate that they had quoted to the effect that the governor would have that authority, again, they quoted out of context, and it was shown very clearly that there was no such intention. And a motion for reconsideration was filed, denied. I've had that happen as a lawyer many times. You file a thoughtful motion and say, please, court, I think you made a mistake, and you please fix it. Oh, no, being a judge is a variation of love story. Being a judge means never having to say you're love. And they won't do it. They will deny motions with a single word, denied without any explanation, and that's what they did in this case. So here we are at an impasse because the judges misapplied the Constitution. They won't admit their mistake, and here we are. I'll close now. I promise I'm done now. But I love this quotation. It tells a lot about where we are in this country with the judiciary. This is from Learned Hand. You may have heard of him. He's often considered the greatest judge in the history of this country who never became a member of the Supreme Court. He was a Republican. He was appointed by Teddy Roosevelt, and by the time he would have been eligible, mature enough for the Supreme Court, the other Roosevelt was in the White House, and that was that for Learned Hand. But he served for many years in the Federal Court of Appeals that sits in New York City. Anyway, he said this about judicial review. He said, judges wrap up their veto in a protective veil of adjectives such as arbitrary, reasonable, inherently, fundamental, or essential, whose office usually is to disguise what they are doing and impute to it a derivation far more impressive than their personal preferences, which is all that in fact lie behind their decisions. And that's what we're confronted with in New Hampshire. And I hope you will work to enlighten people about what's going on with the judiciary so that our efforts, which have been going on for many years to put reins on them, will one day be successful. Thank you.